Okay. Welcome to the National Bar Association's Historical Committee CLE program for 2023. I am Jimmy Lynn Ramsour. I am the chair of the NBA Historical Committee this year, and I'm a former legal aid lawyer, a proud one. I thank you to the National Bar Association Historical Committee, particularly to Rebecca Lyford and Mary Burrs, as well as to the staff of the NBA and the president, Ghulam Zaid, for the support and effort they put into making this program possible. We want to give a special thank you to the Federal Court Bench and Bar Fund and to Chief Judge Waverly Crenshaw for helping to make this program free to everyone. And we are happy to have Judge Crenshaw with us here today.
Well, thank you for inviting me to be here today. I'm very pleased to be here because the Bench and Bar Fund for the Middle District of Tennessee is supporting this program today. And we've actually done so for at least the past 7 consecutive years, particularly the NBA Historical CLE. We do so because these programs are important because they document our history as lawyers, and each lawyer has made their own individual contribution to advance the administration of justice here in the Middle District. And these historical CLEs are always very interesting. Well, I'm here today because this year's program has a special connection to me. In the summer of 1979, after my first year in law school, Ashley Wiltshire hired me as a summer clerk at what was then known as Legal Services of Middle Tennessee. And before I ever started at work, I learned a lot about Legal Services of Middle Tennessee, and I really came to appreciate who I would be working for with Ashley Wiltshire. Because even though Ashley had made the offer, and I had accepted and relied upon that offer and acceptance, I learned that Legal Services of Middle Tennessee sometimes engages in matters that become very controversial and very political. And unbeknownst to me, certain people in the community did not want legal services to continue to bring class actions. So they thought one way of trying to temper that enthusiasm for class action was to withdraw funds. Well, little did I know that they withdrew the funds that were going to pay for my summer associate position. But then I learned about Ashley Wiltshire, and I actually learned about his character and his values. And notwithstanding the fact that the funds had been withdrawn, Ashley told me, well, you still have a job. I promised you a job, and we'll find a way to fund the job, and they did. So my first job in the legal field was with Legal Services of Middle Tennessee, and I worked with Russ Overby, Mary Walker, Kitty Calhoun, Jimmy Lynn, Robert Green, and many other lawyers on all types of cases, Social Security, eviction, consumer protection cases. And it was such a wonderful experience, I asked and was allowed to come back the second year. And during the second summer, I worked on one of the biggest cases in the office with Bill West, who I'm sure will be here. Bill is here. And the case I worked on with Bill was a class action, oddly enough, housing race discrimination case involving a Section 8 housing project right here in Tennessee. The case was assigned to Judge L. Clure Morton, so I got a fast lesson on the no-nonsense demands of federal court. And then I got to be engaged in the discovery process that was very, very much active during the time I was there that summer. And in fact, Bill and I and a team of many lawyers poured through hundreds, perhaps thousands, of applicants who sought to gain admission into that Section 8 housing project. And I actually got to experience the thrill of discovery, hard to believe, because Bill found one application. I remember the day we were all working, and he said in a loud, gleeful voice that he's found this application on which a property manager had wrote, quote, black but nice, has light skin and brown eyes. And Bill thought, we all thought, that tends to prove that race was a factor. And so did Judge Morton, because he later cited that application in his findings that the housing project had indeed discriminated on the basis of race. It went on to the Sixth Circuit, where a substantial class action award of damages was made. So obviously the lawyers working for an organization like the Legal Aid Society provide a vital public service every day as they represent the disadvantaged in our community. The preamble to the rules, paragraph 7 specifically states that, quote, all lawyers should ensure equal access to our system of justice, and for those who because of economic or social barriers cannot afford or secure adequate legal counsel. This year's program is important because it emphasizes public service. It's important that members of our profession never forget that the license to practice law is a public trust. And in the words of the comment to Rule 6 of our Rules of Professional Conduct, a lawyer has a responsibility to provide legal services to those unable to pay. Rule 6 lists providing pro bono legal services as a way to fulfill that obligation. And the comment notes it can be one of the most rewarding experiences in the life of a lawyer. So today's and this afternoon's historical CLE will tell the stories of some of those rewarding life experiences that span more than 25 years during the last century. Some of you may remember those cases, indeed some of you were involved in those cases. But for others, you may have come to the bar more recently, and this may be new material. So I hope everyone enjoys today's telling of these stories. I hope you remember these stories. But most of all, I hope they touch your heart, they touch your mind, they touch your soul in such a way that your personal commitment to equal access to our system of justice becomes part of your DNA. These certainties and the experience I had at Legal Services of Middle Tennessee did that for me. So enjoy the program.
Thank you, Judge Crenshaw. Those are inspiring words. And I do remember working with you. It's fun to think back all the people that I worked with when I was at Legal Services. This is a story about a revolution in the law in Tennessee in the years between 1969 and 1996, specifically about the part played by legal aid lawyers in that revolution. It is a story about due process and equal protection and the enforcement of U.S. Supreme Court decisions. It is also a story about the opposition to those advancements in the law and the opposition to legal aid lawyers and the organization that employed them. Things were different and difficult in the early years of Legal Aid Society, then as known as Legal Services of Nashville. In 1972, when Walter Kurtz, as a law student practicing under Tennessee's Supreme Court third-year practice rule at Legal Services, argued in Chancery Court challenging the fee charge for low-income women to file a divorce under the Pauper's Oath, he cited a U.S. Supreme Court decision in Bodie versus Connecticut, one I'm sure you all are familiar with. It was a case precisely on point. Chancellor Ned Lentz abruptly stopped Walt's argument with the admonition, quote, "Mr. Kurtz, Justice Berger can run his court up there and rule however he wants to, but I'm running my court down here." Earlier that year, when Walt presented a motion in General Sessions Court to Judge Dennis Summers, remember him, asking for the release of a woman the judge had sent to the workhouse that morning in violation of the U.S. Supreme Court holding in Tate versus Short, and in violation of the agreed order signed by Federal District Judge L. Clore Morton enforcing that holding, Judge Summers balled up the paper that the motion was written on, threw it back at Walt. And we'll hear more in a few minutes about the outcome of that event. The challenges were persistent. They came not only in the courts. In Washington, there was a resistance to funding local organizations like Legal Services of Middle Tennessee. What we will hear today is that despite the difficulties, the advancements in the law in Tennessee brought about the work of legal services lawyers were many. Thanks to more responsive judges, responsible legislators, and some sympathetic administrators, many changes occurred. For example, Low-income women were allowed to file for divorce in forma pauperis without paying a fee. General Sessions judges were prohibited from converting metro fines into jail sentences for low-income people. Judges could not remove a legal services lawyer from a case because he thought her client was not poor enough. Developmentally disabled people could not be committed to a state institution without due process of law, and they were entitled to rehabilitative services if they were under state care. A questionable insurance product sold only to low-income people was attacked and reformed. Homes were saved from foreclosure. Fraudulent home repair schemes were thwarted. The state was prohibited from seizing a person's automobile without due process. The standard of need was changed so that more poor families qualified for financial assistance in medical care. More than 350,000 children began to receive school breakfasts annually. And although it was a problem that had been present for centuries, for the first time, lawyers, courts, and legislatures began to recognize the persistent and perniciousness of domestic violence. It was a long road with much opposition, both locally and nationally. This afternoon, we will hear about both the ups and the downs. The program is based on the book, Everyday Justice by Ashley Wiltshire, which was published earlier this year by Vanderbilt Press. Ashley was with Legal Aid Society for 37 years, beginning in 1970, and he was the executive director from 1976 until he retired in 2007. He will set the stage for us with a bit of prehistory.
Thank you, Jimmy Lynn. Thank you. In this prehistory, I'm going to hopscotch a bit from something that happened in 1941 to something that began in 1915 to a problem that arose in 1965. So, September 1941, the National Bar Association filed a bill in Chancery seeking the disbarment of a young lawyer, Joe Lackey, because he had dared to represent a great number of low-income people who had tried to get their cash surrender value on their industrial insurance policies back from the Metropolitan Life Insurance Company. We will hear later from Margaret Bam a lot about industrial insurance, but for now, just know that it was a low-dollar product that was sold door-to-door exclusively in low-income neighborhoods, much to the enrichment of several large insurance companies, and with little benefit to the policyholders. The Bar Association did everything it could to avoid paying these people, and when the policyholders could not get the company to respond to them, then many of them found their way to Joe Lackey and his office. And he filed suit on behalf of them when the insurance company would not even deal with him. At one point, he had as many as 200 cases pending in the courts. And he was often successful, if not in General Sessions, then in circuit or chancery, and if not there, then in the Court of Appeals. The two local lawyers for the Metropolitan Life Insurance Company charged that he was guilty of unethical practice and announced to the NBA board that the insurance company was willing to pay for the prosecution of a disbarment case against him. The bar shamelessly accepted the offer, and a grievance committee was convened and conducted extraordinary hearings. They were public hearings, and they lasted for 6 days, exposing him to all kinds of public ridicule. And finally, of course, the committee voted that he was guilty and should be disbarred. This was before we had a board of professional responsibility, and this was handled then by the local bar association and then filing suits in chancery. So they charged him with filing unnecessary suits and the improper use of the attorney lien statutes, despite the fact, as the Court of Appeals later pointed out, that court and others had found in his favor 150 times on the attorney lien question. But the Bar Association filed its suit in Chancery. 15 months later, in December of 1942, it came to trial. The bar put on its evidence furnished by the insurance company, and it rested. And then the defense began.
The first witness was Mr. Raymond Denny, who was president of the Nashville Bar Association. There were other witnesses, according to what I've been told. There were other attorneys that came to this hearing and had anticipated being called as witnesses on behalf of Mr. Lackey. The court, I don't know how soon after Mr. Denny testified, but the court adjourned. 4 days later, the attorneys that had been appointed to represent the Bar Association in the prosecution of the suit against Mr. Lackey, my father, they wanted to appear before the board of directors of the Nashville Bar Association, which they did. And they told the Bar Association that there had been proof shown to them that made them feel that they could not proceed representing the Bar Association, and that they wanted authority to get the case dismissed if they were going to stay on as attorneys. And if they weren't going to have the authority to dismiss the case, they wanted the Bar Association to appoint other counsel. The Bar Association, the directors at that meeting unanimously voted on motion of Mr. Reba Bolt that the case be dismissed. And it was dismissed, in fact, on just a few days later.
By the end of this and related matters, Joe Lackey Sr. Had spent a decade of his young life hounded by the largest insurance company in America and its local attorneys and his own bar association for daring to represent aggressively these people who, because of their poverty and ignorance, could not help themselves. For him, it had been a long and lonely road. 35 years later, after Joe Lackey's trial, things were different. When Margaret took on not one insurance company, but the whole industrial insurance scheme, she had behind her support in the community, support from the press, and an established legal aid organization, its staff and its board behind her. And the process that led to the formulation of that organization is what I'm going to talk about in a few moments. But first, another piece of prehistory. Even though I was with legal aid for all those years, it was not until I was doing research for the book that I learned we had a predecessor. In 1915, the Nashville Bar and Library Association, as it was called then, established a legal aid bureau. And it was funded and managed, interestingly enough, by what was then called the Commercial Club, which is now the Chamber of Commerce. It seems to have been a combination of pro bono and lawyer referral system. And though it had an attorney manager for much of its history, it seems to have been a rather low-key operation. You'll notice that there's no reference to the Legal Aid Bureau in the story about Joe Lackey. In time, the management of this organization passed to the community chest and then to the Council of Community Services, which was a social work organization. By 1946, the social workers figured this is something the bar ought to be doing, and they decided to abolish their legal aid bureau and asked the bar to establish one. it took a couple years, but a couple years later, the Bar Association voted not to establish a staffed program, but that they would start a clinic that was open only on Wednesday afternoons for an hour and a half in the third floor of the courthouse, later moved to the bar office in the Stallman building. A volunteer lawyer or a law student would go there on Wednesday afternoon and sit and give advice or referral to, quote, any worthy indigent citizen of the community found to be entitled to assistance. And that's the way it was for nearly 20 years after that. In 1965, the NBA, according to its minutes, had a problem. The problem had to do with the fact that the Office of Economic Opportunity, as part of the war on poverty, was funding staffed offices of lawyers to render legal services to poor people. The year before, President Lyndon Johnson had declared war on poverty and had established the Office of Economic Opportunity, OEO, and asked Sergeant Shriver to be the head of that. Shriver was convinced, had a little persuasion, that lawyers could be a part of this, and so then with the great help of Lewis Powell, who was then the president of the American Bar Association, later Supreme Court Justice, they established the OEO Office of Legal Services to give grants to existing legal aid organizations and to fund new ones in places like Nashville that did not have one. Part of the problem for the NBA was that low-income people, non-lawyers, would be on the boards of these OEO-funded organizations. They would be majority lawyers, but others would be involved as well. Furthermore, any organization funded by OEO would be an integrated organization, bringing together both blacks and whites in the same organization. It would bridge the traditional divides between whites and blacks and between low-income people and others in the community, thus threatening the hierarchies of both race and culture. Empowering low-income people was not something that had been done in our country. It was something new, and certainly it was not part of our Southern way of life. In the midst of all this, the president of the Tennessee Bar Association and the executive director wrote an article in the Tennessee Bar Journal, an impassioned article, Et tu, Brute, in which they excoriated the OEO Legal Services Program and called it a headlong plunge into socialism. A few months later, that president of the Bar Association appeared at a conference of bar presidents in Chicago and rose up to accuse OEO Legal Services of fomenting social unrest and inciting social revolution. Hopefully he was right on the second one. The NBA committee that had been appointed to look into the problem reported 2 months later and recommended that the NBA not sponsor or co-sponsor a legal services organization. Its stated reason was that such an organization would be in violation of the canons of ethics. They were particularly concerned about violations of lawyer advertising, stirring up litigation, the use of intermediaries like paralegals and community education people, and aiding in the unauthorized practice of law. The NBA accepted the report of the committee and voted to do nothing. And with that, the matter may have died, except for the intervention of one lawyer, and that was Lewis Pride. Lewis was at that point a state legislator from Belle Meade, who was active in community life and was also a member of an ABA Young Lawyers section that had been promoting legal services all around the country, when he discovered what was happening or not happening in his own backyard, then he immediately contacted the new president of the Bar Association, Woody Sims, and said, look here, something needs to be done here. So Woody asked the committee to reconvene. They did and met. And then a year after Louis Pride's letter, let's see, I skipped something. This is when, at the same time he contacted Woody Sims, he also apparently contacted his friends, Sandra, at the Tennessean, because this editorial appeared that said, for a group that needs to improve its public image, this voting down of legal aid is unfortunate. Anyway, the committee reconvened. It reported the next year, and in its grudging report, it conceded that it is inevitable that a federally subsidized legal aid program will be authorized in the future, and the committee reluctantly recommended that the NBA establish a legal services program. After that ringing endorsement, the NBA board, not surprisingly, did nothing for month after month. And then Louis Pride once again jumped and raised the alarm. He knew that with a few months, Nashville would be the largest city in the country not to have a legal services program. Furthermore, he was frustrated that the NBA's delay would allow another organization to come in and get the grant. He said, I've been preaching all over the country that I thought it much better for the organized bar to handle these matters, but we will have very little to stand on if we continue to drag our feet. He had insisted from the beginning he didn't want to be on any committee, but he relented. The bar president appointed him and Carl Warden, who taught many of us at Vanderbilt Law School, and also Tommy Smith, who had been on the original committee in 1985. It took them nearly 5 months, but finally they reported to the NBA and were invited to the meeting of the board in November of 1967. The board questioned them for an hour and 45 minutes. So extraordinary that it's noted in the minutes of the board how long this went on. After that, they were, quote, excused from the meeting. They came back in December with modifications, and this time they were questioned, again, according to the minutes, for an hour. Then they were excused from this meeting, and the board undertook further deliberation. Finally, the board decided not to decide. Instead, the board decided that this was too hot to handle, and instead they would submit it for a referendum of the entire membership, which is extraordinary. I don't know that this has ever happened except one other time in modern history, and that was in 1965 when the board had a referendum to decide whether or not to allow black lawyers to membership. That had been approved by a vote of 260 to 175 against. The question of whether or not to have a legal services organization would not only have racial issues, but also political and social issues as well. And there were these persistent fears that having a legal aid organization would take business away from lawyers who were just barely getting by. And there were these persistent ethical issues. One former president of the Bar Association sent a letter to every member of the association claiming that the proposal is illegal and could subject the lawyers participating in the program to charges of unprofessional conduct. He later did charge us with unprofessional conduct, as Walt Kurtz will tell you in just a few minutes. When the votes were counted, thankfully, in February 1968, the measure passed by a vote of 206 to 171. The board quickly incorporated the Legal Services of Nashville. 5 days later, Billy Howard and Lewis, Billy Howard was the new president of the bar, and Lewis Pride submitted a grant to OEO. The board named the first board of directors, and Harris Gilbert was elected president. Lewis Pride agreed to be secretary. But it was too late. OEO was out of money, had no money to fund new organizations. But that didn't deter the committee. They decided they were going to raise money in the community and have a legal aid program nevertheless. And so they assembled this nice, stellar fundraising committee and had good support from the Chamber, the Tennessean, and other groups. And one group had a rummage sale for 3 days, but altogether they raised $14,500. And with that, in November, they decided they were going to hire an executive director and open operations as soon as possible after the first of the year. Then, in December, surprisingly, came news that in the new fiscal year, OEO had money, and LSON could get a grant for $95,000, half the amount that Billy Howard and Lewis Pride had requested, but they were glad to get it. And on February the 3rd, 1969, John Corbett, the executive director, opened the office at 615 Stallman Building and interviewed the first client. Dave Tarpley and I began as paid clerks in June the next year. Then in September, we were joined by Walt Kurtz, who now will come talk about a couple of important people in our history and a couple of important cases.
Well, as a second-year law student, I signed up at Legal Services as a student assistant, and the following year, as a third-year law student, was certified by the Supreme Court to practice if I was well supervised. Later in the story, you'll have to determine whether I was well supervised enough. Let me first say that one thing about the early days of legal services in the very early 70s is we were blessed with two lawyers, Rita and Paul Geyer. Paul had a married couple. Paul had graduated from Vanderbilt in 1970, Rita in 71. Now, you may well have heard of Rita Sanders Geyer because she was a plaintiff in the major civil rights case related to Tennessee State and the Nashville portion of UT, a case that went on for a long time that related to racial discrimination in the administration of the higher education system here. And so Rita and Paul were very, very good lawyers, and they filed the first class action cases that were filed by Legal Services, having to do with educational opportunities, due process in automobile forfeiture cases, denial of unemployment claims, and the jailing of indigents for non-payment of fines, which I'll get to momentarily. Both Rita and Paul really set the tenor for us and were the mentors of young lawyers like me and Gordon and Ashley and the other young lawyers. They were both committed to the cause of legal aid, but they were also the kind of lawyers that dotted the I's and crossed the T's, and they set an example for us. Both went on to significant success in their legal careers. Rita became the director of legal aid in Seattle. Later, she worked for the Justice Department for a long period of time, was a #2 administrator in the Social Security Administration, and then at some point, a aide to the chancellor of UT Knoxville, and there is now a dormitory named after her at UT Knoxville. I think that is because of her role in the Geyer versus Tennessee case. Paul went to work for the United States Department of Energy, and then the Department of Transportation, where he is the head of their legal division. Now, as a third-year law student, I was assigned to intake, and one day in 1972, an event happened which brought about probably the most exciting, I shouldn't say probably, the most exciting day in my entire legal career, even though it was 50-some years ago. In 1971, the U.S. Supreme Court had decided that indigents cannot be jailed for non-payment of fines and costs in a criminal matter since they don't have the means to pay. Other people with the means can pay and not do jail time. The court decided that was a denial of equal protection, and the indigent had to be given reasonable alternatives like installment payments or at least to work out the fines. The General Sessions judges here in Davidson County, I know this is hard to believe, in 1971, did not pay any attention to the case. So legal aid, legal services filed a lawsuit. The judges were represented by Metro Legal, by a lawyer named Larry Snedeker, who some of you might know. And there was really no defense. Judge Morton looked at the pleadings, he issued an injunction, end of story. Except fast forward a few months and I'm on intake and a woman comes in and says, my daughter yesterday was fined $100 for 2 Metro ordinance violations, and the judge sent her to jail. And she couldn't afford to pay, and she told him that she couldn't afford to pay. I said, well, let me see if I can get that straightened out. And I drew up a motion. I knew who the judge was. His name was Dennis Summers. And I went over to the courthouse. He happened, coincidentally, to be on break, and I walked up to the judge and I said, Judge, I'm here to represent Jacqueline Parrish, a woman you sent to jail because she couldn't pay fines. And I handed him the motion, and he crumpled the motion up and tossed it back to me. Now, I practiced law for 10 years before I became a judge, and I've lost my share of motions, but I never had a judge toss one back to me. Nor do I want to assure you as a judge that I ever crumple one up and throw it back. This was an emphatic denial of the motion. And he said to me in no uncertain terms, Judge Morton can issue all the orders he wants. He doesn't do anything he doesn't have any authority over me. So I went back to our office in the Stallman buildings, and I called Rita Geyer, who is down in our office in South Nashville. I said, Rita, you won't believe what happened. And I explained it to her, and she said, well, I want you to fill out an affidavit, and I'm going to draw a petition to hold him in contempt, which she did post haste, and I got she came uptown, I gave her the affidavit, and she filed it. As it happened, Judge Morton was on vacation, but Judge Frank Gray was I shouldn't say in town, he was actually at his house in Franklin. The clerk called Judge Gray. Now, many of you don't know Judge Gray, but there's a few who know him. He's could be an emphatic person on occasion, and this day he was emphatic. He ordered the marshal to serve a show cause order that day on the sessions judge. The marshals went into court and served the judge, the general sessions judge, an order to show cause, not in the federal courthouse, but in Judge Gray's library down in Franklin. So we all convened down in Franklin. Rita and Paul Geyer, me, Dave Tarpley, another legal aid lawyer, was there, Larry Snedeker, and Judge Summers. I must say, to me, Judge Summers looked sufficiently nervous. Judge Gray looked at the file for about 10 minutes, and he turned to the Judge Summers, and said, "What do you have to say for yourself?" And he said, "Well, let me say this. I'll never do it again, no matter what happens. You'll never see me in here again. And I will ensure that this order of Judge Morton is carried out." So Judge Summers was released to go back, and Judge Gray signed an order immediately releasing Jacqueline Parrish. And Rita Geyer was kind enough, she said, "Walt, since you started this today, take the order over and get Miss Parrish out." So I took the order over to the jail, and the jail superintendent said, "Well, we've been expecting you, and here, she's ready to go." So he took the order. She walked out with me to the door out on, I guess that's Main Street, and there were TV cameras all around. And she, this is a law student's fantasy. She said, "There's justice in this world. There's justice in the world." And I've got all these cameras on me. I thought I was, Bill Kunstler. But it was, quite a day for me. And I must say, the sessions judges none of them ever repeated a violation of the U.S. Supreme Court mandate. Interesting, as a side note, I, as a legal aid lawyer, and subsequently as public defender, appeared before Judge Summers on a number of occasions, and he always treated me well and got along well with me. So, and with some humor too. So I must say he did okay in the face of what happened. But it was quite an exciting day for me, and a significant win for legal services, and I think it really sort of put us on the map. I don't know of any case before then where judges had been sued and in a light circumstance. And the Tennessean, Sandra, made big press out of it. Now, the second case I want to mention has to do with Clover Bottom Hospital. We here in Nashville were the home of Clover Bottom Hospital, as well as Middle Tennessee Mental Health Institute for the mentally ill, Clover Bottom Hospital for the intellectually disabled. And I must say, although I won't try not to repeat this again, back in those days called retarded. The formal name of Clover Bottom was Clover Bottom Hospital and School for the Mentally Retarded. And it then, in 1973, housed about 1,100 patients. Most of the residents had been placed in the institution by their parents or wards or county welfare agencies with no hearings, and accepted by the hospital, and a psychologist that once worked there contacted us, Legal Services. He contended that the conditions there were deplorable and that we should look into it. Some of the sympathetic staff members were able to get me into the facility. I visited and saw scores of people milling around in open areas, sleeping in beds a mere 2 feet apart. Many of the patients with vomit and fecal matter on them and on the floor. To clean the patients, the staff sometimes would just hose them down. Some of the residents were kept in cages. Others were chained to radiators. Still many others just sat rocking back and forth on benches for hours on end. Even measured against my experiences in Vietnam as a soldier, the conditions were extraordinarily disturbing. It was a scene of wretchedness, never to be forgotten, and I don't forget it. So we started to get ready to file a lawsuit. Now, let me say, by that time, Gordon Bonnyman had joined the staff at Legal Services, and Gordon was my co-counsel, and we did this together. So from what I tell you from this point on, it was a shared responsibility between me and Gordon. Gordon will talk later about some of his cases, so he's not presenting this one. Now, one thing about the case was, not only did it involve the conditions at Clover Bottom, but it involved how the patients got into Clover Bottom, because there was no real screening of them. I should say that might be somewhat of an overstatement, but we looked at how they got there, and parents could essentially drive up and take their child or adult into the facility and explain why they thought they couldn't care for the child, and the facility would take them. And these days, the facility were just huge buildings, dormitories, and I've already described what it looked like. So the lawsuit that we subsequently filed in April of 1973 was twofold. It attacked the constitutionality, the due process of how people got into the facility, and it challenged the conditions in the facility. Now, in the meantime, obviously the parents nor the guardians were to bring this lawsuit. They were the beneficiaries of the admissions process. They were the beneficiaries of the fact that their children and wards were in the hospital. And so several of the staff members volunteered to be next friends, to bring the lawsuit in the name of the next friends of the patients. And the case was brought as a class action. Now, the state's attorney's reaction to all this was twofold. He filed a motion in front of Judge Morton contending that we had no standing to bring this suit, that only the parents or the court-appointed guardians could bring the lawsuit, and that was in front of Judge Morton. And he filed a bar grievance against him because I guess at some sort of species of solicitation, because the parents did not agree to the case. Now, Ashley's already described for you how in those days before the Board of Professional Responsibility, the bar did its own investigation, and if they thought there was reason to sanction, would take it to Chancery Court. The bar president appointed a 3-person committee to investigate our possible ethical violation, and appointed Dick Lansden as the chair. Now, if you remember in Ashley's presentation, Mr. Lansden, a partner in a very reputable law firm, was a major opponent of legal services. So we were not looking forward to his impartial judgment on this. However, the case proceeded. The Judge Morton denied the motion to disqualify us, and we went on, and the first thing that happened was an argument before a 3-judge court in December 1973, challenging the admissions process. Now, Judge Morton, Judge Gray, and Judge Phillips were the 3 judges. We argued that before the admissions, there needed to be a meaningful hearing with an effective advocate for the prospective admittees. Though the parents or guardians may not want to care for them, they should not be sentenced to a lifetime of incarceration without due process. In less than 3 months, in March 1974, the 3-judge panel issued its decision, quote, where individual liberty is at stake to the extent it is in the present case, it is absolutely essential that such confinement be preceded by adequate procedural safeguards. Yet it was obvious that the voluntary commitment procedures of this statute fall far short of these required by due process. The court held the statute unconstitutional and enjoined further admissions pursuant to it. It was an important decision, the first of its kind in the nation. Then, about 3 or 4 weeks later, Mr. Lansden and his 3-person committee issued its report. It said that we were guilty of unprofessional conduct of the worst sort, and that we should be reprimanded for our actions. And then I was told later by one of the committee members, the only reason they thought that we shouldn't be suspended or disbarred was because of our youthful naivete. Then their recommendation went to the bar board. The president of the bar board then sent it to the chair of the Legal Services Board, who is a lawyer, Brad Reed, who is a very well-respected corporate lawyer at Bass, Berry & Sims. And Brad's response to the bar board was, the only printable response to the report and the recommendation contained therein is one of incredulity. He said Judge Morton had already denied the motion to disqualify us. The attorneys who are the object of the special committee investigation are deserving of commendation, not condemnation. Signaling his resolve, he warned, the last thing I would desire is a fight with the Bar Association. Subsequently, the Bar Board, in a unanimous decision, dismissed the bar complaint, and we were free to go forward. The next step was the issue of the conditions. Shortly after that, in the summer of '74, the United States Department of Justice moved to intervene in the case with the right to conduct discovery, call witnesses, file motions and briefs, and present evidence. The government believed that the case offered a unique opportunity to establish and define the constitutional rights of mentally retarded individuals and the lawyer the Justice Department Civil Rights Division wanted to participate. Gordon Beineman and I argued vociferously that we would welcome the Justice Department participation. However, here's what Judge Morton said. He said, Mr. Kurtz and Mr. Beineman, they don't need the assistance of the U.S. Justice Department. That he had the utmost confidence in us. And we want to say, Judge, hold a minute. Thank you for the compliment, but you're getting a little carried away here. But anyways, however, he denied it, the motion of the government to intervene. But I think at that point, the state saw what was about to happen. And you know, going back over this, I had to think, and I know Gordon and I talked about, this is going to be quite, we'd have to get expert witnesses, and a case like this to prove would be difficult, especially in the early 1970s. But you know, as I thought about it, the photographs of the inside of that institution and the way the patients were treated, I think would have been such a so powerful visually that we'd have been halfway home with that. Anyways, the state could see what was going to happen, and we enter a proposed order establishing the right to protection from abuse, habilitative services, the right to receive those services in the least restrictive environment possible, and extensive due process protections related to the admission decision. And that became the order of the court in very detailed findings that are published in the federal supplement. I had occasion to talk to one of the next friends about 3 weeks ago, who's now in assisted living in Chattanooga. And he remained at Clover Bottom for 6 years after that. And he told me that the judgment of the court really did make a difference, that there was, shortly thereafter, there was considerable more staff hiring, individual treatment plans were mandated for all the patients, there was an attempt to de-institutionalize the habilitative services had to be provided in the least restrictive environment, which meant many of the patients had to be taken out of the hospital and sent to community homes, which then the state was in the process of doing. They built a number of cottages and closed the big dorms. The medical and dental staff was significantly increased, and recreational services were provided. I just might end it with this. I mentioned earlier that how am I doing time-wise? Huh? Yes. I'm out? Yeah, out. 0. Okay. You want me to stop? Yeah. Okay. I just want to tell you that the named plaintiff, Amy Lynn Seville, a decade later, we had information she was out of the institution and she was doing very well in a halfway house.
Thanks, Walt. Access to health care which I'm about to talk about, and dealing with medical debt are among the most serious and most prevalent legal problems of low-income families, and legal services use an array of legal tools to address those problems. Our first major foray into health law began when Callie Mae Newsom came into legal services offices in April of 1975. A hard-working, underpaid aide at Clover Bottom, she was being sued in General Sessions Court by Vanderbilt Hospital for the balance she owed on a recent surgery. Vanderbilt had received federal funds under the 1948 Hill-Burton Act, which subsidized hospital construction in return for grantees' obligation to provide a reasonable volume of care to the poor. For 2 decades, there had been no enforcement, and the obligation was a dead letter. But in 1972, Marilyn Rose, part of Ruth Bader Ginsburg's small coterie of women law students at Harvard, won a ruling against Ochsner Hospital in New Orleans that for the first time enforced a Hill-Burton hospital's obligation to serve the poor. I drafted a cut-and-paste knockoff of the Ochsner complaint and filed a class-action lawsuit in federal court. And when I say cut and paste, it was literally, for younger people, you made a copy, you got out the scissors, you got out the tape. Anyway, that's what I did. It took a lot of creativity. In our case, we added federal officials as defendants, asking that they be ordered to enforce the act. When it came to discovery, we again copied Marilyn's work, sending Vanderbilt a revised version of her interrogatories and requests for admission. Plagiarism and beginner's luck produced the sort of smoking gun every lawyer dreams of, a log with the brutally frank title, "A Weekly Summary of Patients Denied Admission to Vanderbilt Hospital for Financial Reasons." We contacted those patients and compiled gut-wrenching stories that refuted Vanderbilt's blithe assurance that they never turned away patients based on inability to pay. In June 1978, Judge Morton issued a blistering opinion in which he condemned the federal agency's neglect and Vanderbilt's accounting sleight of hand in reporting as charity care services that were actually just bad debts. He fleshed out the obligations that had only been stated in general terms in the Ochsner case. Crucially, he established due process protections in the form of notice and an opportunity for patients to apply for free care, and he required the hospital to apply objective income standards in determining to whom it should allocate such care. Vanderbilt appealed. The Sixth Circuit upheld Judge Morton's findings regarding Vanderbilt's liability, but reversed his due process ruling. Fortunately, by then, the federal agency had incorporated Judge Morton's due process safeguards in regulations that bound more than 3,000 hospitals throughout the nation. Those individual due process guarantees were the key to converting an amorphous obligation that was readily gained by hospital accountants into a concrete right to health care. Hill-Burton hospitals across the nation would eventually deliver $6 billion in free care over the next 15 years before their obligations expired. And I know $6 billion doesn't sound like much to younger people these days, particularly in the context of health care. That's about 2 or 3 good emergency room visits. But back then, that was actually some pretty significant amount of health care resulting from the efforts of LSON. In 1981, in the wake of the Reagan administration cuts in federal Medicaid funding, Tennessee planned to reduce its Medicaid rates for hospitals, which were the highest in the country. But when the hospital lobby pushed back, the state shifted the burden onto the program's politically vulnerable patients. It left the rates in place, but cut the amount of care patients could receive from 20 to 14 days of inpatient care annually. The hospital lobby frankly said, we'd rather be paid more for doing less, and the state obliged. The Sixth Circuit ruled that the reduction in hospital coverage violated the rights of individuals with disabilities under the Vocational Rehabilitation Act of 1973, a precursor to the Americans with Disabilities Act. With Reagan administration cuts in social spending threatening the poor across the country, the Sixth Circuit's ruling offered legal services advocates everywhere a patient legal weapon, a potential legal weapon with which to defend the beleaguered poor. Unfortunately, the Supreme Court granted certiorari on a question fundamental to the nature of discrimination and scope of civil rights protections. Was it sufficient to prove discriminatory effect, as the Sixth Circuit found that we had done, or did the civil rights plaintiffs have to prove intent to discriminate, a nearly impossible standard? Because the Vocational Rehabilitation Act was patterned after other federal civil rights laws, our case, known as Alexander v. Choate, would potentially impact other protected groups, including racial and religious minorities, immigrants, and women. The grant of certiorari therefore set off alarm bells through all of those groups, and I soon found myself meeting with the national leadership of the civil rights bar. The NAACP, the Legal Defense Fund, made famous by the achievements of Thurgood Marshall, wrote most of our brief and shaped my oral argument. Just 3 months after oral argument, in a unanimous opinion written by Justice Marshall, the court made the crucial assumption that intent was not required to prove discrimination, but held that we had failed to meet even the lesser standard by proving that the effect of the state policy was to discriminate against people with disabilities. Thus, the reduction of hospital coverage from 20 to 14 days was upheld. And I don't want to brag, but I'm going to anyway. I think I'm the only civil rights plaintiffs lawyer in the history of the world, maybe the cosmos, who persuaded Thurgood Marshall to rule against the civil rights plaintiffs. So there you have it. You're in the presence of greatness. The day after the decision was announced, the Washington Post reported on the front page that civil rights groups hailed the case as an important victory because it rejected the intent standard. Alexander v. Choate is a seminal case in disability law cited extensively in the legislative history of the Americans with Disabilities Act that was adopted 5 years later. The impact of that reduction for Medicaid patients with severe chronic illness was tragic, however, as we knew it would be. One of the victims was a young mother in my church with chronic asthma who died when she delayed going to the hospital during an asthma attack because she had already exhausted her 14-day quota for the year. Legal services staff see too many such tragedies to adopt the national delusion that, insured or not, in America you can always get good care if you really need it. We learned from the Medicaid cuts that the law is a frail reed in the face of the overwhelming political pressure that accompanies state claims of a budget crisis. Legal services began to pay more attention to healthcare economics and the state budget. A few years after the Alexander case, a very smart, conscientious state official, Steve Reed, flagged for me an obscure regulatory change adopted by the Reagan administration that unwittingly made it easier for states to use donations and taxes from hospitals to meet their Medicaid matching obligations so that they could draw down federal funds for the program. I pitched the concept to the incoming administration of Governor Ned Ray McWhorter. Finance Commissioner David Manning and Medicaid Director Manny Martins bought the idea, sold it to the governor, and these sometimes adversaries became allies of legal services. Tennessee adopted hospital taxes whose revenues were used to meet the state's matching obligations, and the resulting federal drawdown was used to make the hospitals whole through increased Medicaid rates, leaving the state more than enough to match inflation and even expand coverage to pregnant women and their babies. And if that whole arrangement sounds a little sketchy, it is, but it works. When federal Medicaid officials tried to disallow the matching funds, legal services played a crucial role in federal administrative proceedings that upheld the state's entitlement to the money. The arrangement eventually made it financially possible for Governor McWhorter in 1994 to start the visionary Medicaid program known as TennCare, which for several years reduced the percentage of Tennesseans without health coverage to the lowest level in the country. Tennessee's funding arrangement would eventually be adopted by all states, thus benefiting low-income families nationwide. And provider taxes now have ended up leveraging several $100 billion worth of health care for poor people across the country. For several years, legal services represented a coalition of senior and disability groups that waged a bitter legislative fight for nursing home reform. We finally won when Representative Tommy Burnett, who had no equal when it came to winning tough legislative fights, agreed to sponsor our bill. Tommy was a preacher-turned-lawyer who had been convicted of tax evasion. Fentress County voters re-elected him from his prison cell, and Tommy saw our cause as a redemptive path back into the House leadership. With his help, in 1986, we won passage of the most comprehensive nursing home reform law of any state, and Congress borrowed many parts of the Tennessee law when it enacted major federal nursing home reform in 1987. Alas, Tommy was as self-destructive as he was brilliant, and he went back to prison to do time for corruption. Disbarred, he ended up raising chickens, having a talk radio show, selling fireworks, and lobbying his old friends in the General Assembly. And now we will transition to a discussion of the Legal Aid Society's 18-year litigation of prison conditions. Kitty Calhoun, Drake Holliday, Russ Overby, David Kozlowski, and Susan Kay were all extensively involved, but unfortunately you're stuck with me as the narrator. In 1937, a state report that then law student Juliet Griffin, this then being in 1970s, unearthed from the state archives, cataloged atrocious conditions prevailing in Tennessee prisons in the 1930s. It pointed out that people were coming out of prison worse than they went in and concluded we are now reaping a bitter harvest. By the 1970s, things had only gotten worse. In 1975, Legal Services accepted a request from prisoners to represent them in Trigg v. Blanton, a case they had filed pro se challenging conditions throughout the state prison system. We made the unusual decision to litigate in Davidson County Chancery Court, whereas elsewhere in the country, other cases are being filed in federal court. There were two reasons. First, the Tennessee Constitution not only included its version of the federal Constitution's prohibition against cruel and unusual punishment, it also included a guarantee of, quote, safe and comfortable prisons and the, quote, humane treatment of prisoners. This was part of the 1870 Constitution that was adopted that reflected the brutal Civil War experience of prisoners, both North and South, that were part of that convention. Second, the Trigg case was pending before Chancellor Ben Cantrell, who was widely respected as a fair and thoughtful judge. When we entered our appearances in Trigg, Walt and I had been practicing less than 3 years. Russ Overby, Drake Holliday, David Kozlowski, and Susan Kay less than that. We were all very green, and there were no grown-ups at Legal Services to teach us. Fortunately, Joe Engel at the Southern Prison Ministry recruited storied civil rights lawyer Alvin Bronstein at the ACLU's National Prison Project to be our co-counsel. Getting to work with Al was like being in a clinic. And by the way, I heard not from him, but from others, stories of his representation of Martin Luther King in Mississippi, one of which involved climbing out of a men's restroom in the back of a country store as Ku Klux Klanners were coming in the front door. The first thing I learned from Al was the strategic value of being empathetic. I was judgmental and self-righteous in my attitude towards state officials. So when this famous New York trial lawyer gave the opening statement in the Trigg trial, I expected to be fiery and harsh, a better job of what I would have done. Al did not pull his punches in condemning the conditions in the prison or the appalling violence, but far from vilifying the system's administrators, Al cast them as well-intended but powerless, crediting them with the desire to run a constitutional system, but bound by political constraints that made that impossible. As a matter of fact, with few notable exceptions, his favorable characterization of state officials proved largely correct, as subsequent events would show. It was also shrewd because Al then argued that the inability of even capable and conscientious administrators to reform longstanding evils was powerful evidence that without judicial intervention, the system would never achieve constitutional compliance. He also limited the standard the plaintiffs would need to meet in order to convince the chancellor to rule in their favor. We didn't have to discredit the defendants personally, as we weren't asking the court to pass judgment on their competence or character. The court need only look at the terrible conditions and the fact that those conditions had persisted unchecked for decades. I also watched Al meticulously draft and flawlessly deliver 2 cross-examinations that were tutorials on trial practice. Al cross-examined the state's 2 expert witnesses, both nationally prominent prison administrators from other states. One asserted that the Tennessee compared favorably with conditions throughout the country, while the other conceded that conditions were troubling, but claimed that state officials' plans for reform would transform the system without need for judicial interference. I stopped by Al's motel room the night before the first expert was testifying. I heard someone talking in the bathroom, but I thought he was the only one there. In fact, he was the only one there. It was Al rehearsing in front of the bathroom mirror. He said they had the cross down to 12 minutes, but it was still too long, and he wasn't going to dinner until he had honed it to a sharper point. The next day, the state's expert testified nearly all day on direct. After 11 minutes of cross-examination, everyone in the courtroom perceived the witness as a hack who, for the right amount of money, would cynically defend any conditions, no matter how atrocious. Later that week, the second expert, having watched the first, still had nerve to get in the ring and testified almost all day. By the time Al rose to cross-examine, in 15 minutes, Al forced the other expert to acknowledge that the system was terrible in all material respects and that his endorsement of the state's reform plan was based on nothing more than wishful thinking. These were lessons in tailoring cross-examination around a theory of the witness, then honing the cross to make a very few key points as concisely as possible. We had a nearly month-long trial, and in June 1978, Chancellor Cantrell handed down an eloquent 40-page decision carefully documenting the proof supporting his conclusion that the system violated the state and federal constitutions. Violations included the state's deliberate indifference to prisoners' needs for medical or mental health care, the failure to protect prisoners from systemic pervasive violence, and confinement in dangerously unsanitary conditions and fire traps. The Attorney General appealed to the Court of Appeals. After a year's delay, the court vacated the Chancellor's decision without citing a single case or piece of evidence, declaring simply that the record was stale by then and that the case would have to be retried. In an opinion written by Judge Henry Todd, who I heard from old hands around Davidson County had been a general sessions judge, and he was so unpopular that they contrived to get him kicked upstairs to the Court of Appeals to get him out of Davidson County. Anyway, Judge Todd admonished the Chancellor not to make findings about systemic conditions, but to only take proof on individual events. In short, meaningful relief was off limits. Enter Judge Morton. He had been receiving a steady stream of pro se complaints from prisoners, but he had abstained in deference to the state courts. Then in 1980, 3 months after we had appealed Trigg to the Tennessee Supreme Court, the Sixth Circuit came down with a ruling in an Ohio case, Hannah v. Toner, holding that abstention by a federal court was inappropriate in cases challenging institutional violations of constitutional rights. Judge Morton took a pro se case off the retired docket, placed it on the active docket, and appointed me to represent the plaintiffs. A conflict arose among the plaintiffs when I persuaded some, but not all, to drop claims for damages against individual prison officials, a non-viable claim that threatened to derail the case and foreclose any chance to obtain meaningful injunctive relief. After seeking guidance from the Board of Professional Responsibility, I asked Judge Morton to appoint other counsel for those plaintiffs who did not want me to represent them. They must have heard about my achievements in front of the Supreme Court. He appointed Bassberry and Sims to represent them. Legal Services and Bass had just been before him on opposite sides of the Vanderbilt-Hill-Burton case, which had become acrimonious. He knew that Bass would do great work. I suspect he also thought the experience of collaborating with former adversaries would teach me a lesson about professionalism and collegiality, which it did. Bass associates Dale Grimes and Cliff Knowles, backed by the full resources of the firm, essentially worked full-time on the case for a year and made enormous contributions to our eventual success. Judge Morton announced at a pretrial conference that he read Chancellor Cantrell's meticulous ruling and that he intended to treat that as a baseline. The parties need only to prove whether the Chancellor's findings were a valid reflection of current conditions. With the request for admission and extensive documentary record, the trial lasted only 3 days, and we proved that conditions had actually worsened. In August 1982, Judge Morton issued a comprehensive ruling consistent with Chancellor Cantrell's findings from 4 years earlier. Judge Morton appointed a special master to oversee implementation of a remedy, Pat McManus, a former Catholic priest and prison administrator, first in Minnesota and then in Kansas. Pat was charming and diplomatic and played good cop to Judge Morton's bad cop. As he worked with prison administrators, he identified those with talent and mutually respectful relationships developed. But administrators were hamstrung by the politicians, and in fact, Al Bronstein's characterization of the situation in his opening argument proved correct. For 2 years, the Alexander administration dissembled, dodged, and distracted, treating prison policy as a public relations issue rather than the deepening crisis that it was. By early 1984, the special master had seen enough of that bad faith. Pat McManus's good cop routine was no longer working, and he needed the backup of Judge Morton as the bad cop. Judge Morton could be a bad cop. Although he was gravely ill by that time, Judge Morton took up that role at a conference in his chambers in Cookeville. By that time, he was no longer holding court here. He was holding court in Cookeville because his wife had been ostracized socially, and they had been subject to threats and required around-the-clock marshal's protection because of his rulings requiring busing in the school desegregation case in which Dick Lanston was lead counsel for the defendants. Judge Morton quickly turned to counsel for Governor Alexander and threatened to release 1,000 prisoners if the parties did not bring him a remedial plan to control the violence, and said that he would name names and make clear to the public whose fault it was in his requiring the release of the prisoners. That got the governor's attention. That led to 3-day marathon negotiations with Pat McManus skillfully mediating the discussion. Deputy Attorney Generals John Southworth and Jennifer Helton Small, as well as outgoing Attorney General Bill Leach and incoming AG Mike Cody, ably represented the state while working to convince their clients to play constructive roles. The parties agreed that Pat would hire an array of experts to work with prison administrators to craft a comprehensive remedial plan. To relieve critical overcrowding, the state was ordered to reduce the population at the main prison by 50 inmates per month. For the first time in 9 years of litigation, there seemed to be cause for hope, but that was short-lived. The state failed to live up to its promises and falsified reports to cover up that failure. Just before an inspection, they would load up buses and ship prisoners to the next prison down the road to get the count down. The violence inside the walls increased. The system was a powder keg, and the politicians just kept grandstanding. At that point, according to DOJ statistics, we had the most violent prison system in the country. Legislators enacted a law requiring prisoners to wear striped uniforms, evoking the good old days of chain gangs and convict labor. On July 2, 1985, the powder keg exploded. A riot began at the main prison when prisoners gathered in the yard and burned the hated striped uniforms. Summoned to the prison, I found a terrifying scene with hostages inside and hundreds of heavily armed riot police eager to mount an assault. Tragedy was averted when several of our courageous clients, and I just want to put in a plug for Legal Services Courageous Clients, and all of these class actions, it takes real guts to be a class representative, particularly if you're poor and powerless. And our prison plaintiffs were no exception to that. Several of our courageous clients risked their own lives to convince their hotheads to release the hostages unharmed, and they were retaliated against subsequently for their courage by the prison guards. Riots also erupted at prisons across the state. Turney Center lay in ruins. There were numerous stabbings, and an inmate was killed at Brushy Mountain. Still, the politicians dawdled, forcing the court to act. In May 1985, Judge Morton, who was increasingly frail, recused himself, and the case went to Judge Thomas Higgins, prominent Nashville lawyer and friend of the governor, only recently appointed to the bench by President Ronald Reagan. Judge Higgins quickly dispelled any thought that friendship or politics might influence his actions on the bench. At a hearing in October requested by the special master, Judge Higgins enjoined the state from admitting any more inmates into the system until it had eliminated the crowding in 3 reception centers. And this was the sort of politically shrewd as well as legally thoughtful approach that Judge Morton took. They both combined great political skills as well and the ability to perform and project power and, in some cases, terror. The effects of that shrewd order were immediately felt as prisoners backed up in jails in every county and legislative district across the state. And suddenly there was a constituency for reform coming from the sheriffs up to the legislature and the governor. News media, especially in Nashville, had extensively covered the crisis for years and had not been shy about calling out the posturing of the politicians. And we hear so much about the atrophy of the press and the media, and it's true. We would not have gotten the results that we got in the prison litigation or numerous other cases, Clover Bottom, but for the really great quality of reporting by the news media that was informed, sustained, and you had reporters who had a beat, they understood the issue, and they informed it and could inform their public the way we don't have, unfortunately, anymore. And because of that reporting, the public began to understand that it was the politicians who were at fault, and efforts to pillory the federal courts or the plaintiffs didn't really work anymore. Finally, the governor called the legislature into special session, and despite initial grandstanding and threats to adjourn, in the end the legislators did what their leaders had long known was necessary. They asked the special master and his experts to testify at committee hearings that served as extended tutorials on prison administration and criminal justice policy. The special session created a sentencing commission chaired by Nashville Judge Barbara Haynes that radically reformed and rationalized criminal sentencing laws to address the root causes of the overcrowding crisis. The legislature gave the Department of Correction the resources and political support to finally implement the reform plan developed with the help of the special master and the 6 experts that had been brought in. The dramatic effects of 1985, from the July riots to the successful conclusion of the special legislative session a few months later, were a turning point. Once they had the resources and political running room to do so, state prison administrators threw themselves into implementation of the reform plan. Although the case wasn't closed until 1993, most of the reforms were implemented within 2 years of the legislative session, eliminating horrific conditions that had festered for nearly a century. The infamous Tennessee State Prison, known as the Walls, and notorious Brushy Mountain Prison were permanently closed. The Walls had a brief second life as a movie set, and Brushy Mountain is now an improbable tourist destination and an entertainment venue. I wouldn't have a lot of hopes for a marriage that was contracted in that venue. But anyway, apparently people feel differently about that. Tennessee became the first state in the nation to win full accreditation of all of its prisons. The case vindicated the role of the court as catalysts of reform and guardians of constitutional rights. Over 18 years, across the terms of 3 governors and countless legislators, the persistence of 3 courageous, politically skilled, and resolutely principled judges, Chancellor Cantrell, Judge Morton, and Judge Higgins, had outlasted the political games and weathered demagogic attacks. Excellent, sustained journalistic attention was essential, as was the dedication of hundreds of state employees who had always wanted to do the right thing, but weren't allowed to do so until the courts made it possible. The story is incomplete without acknowledging a sad sequel. In 1995, Congress passed the misnamed Prison Litigation Reform Act, which stripped federal courts of jurisdiction to grant the sort of relief that the plaintiffs obtained in the Grubbs case. The legislation, like the restrictions Congress had imposed on legal services the previous year, betrayed a lack of confidence in our Constitution and our judicial system, which is unworthy of a nation that proclaims its commitment to the rule of law. We can be proud that former Tennessee Attorneys General Bill Leach and Mike Cody urged Congress to reject the legislation. They wrote that the legislation was unnecessary, citing the courts handling the Grubbs case as evidence that the judicial system was already capable of fairly disposing of such cases. And they concluded that the court's vindication of the Constitution had benefited not only the plaintiffs, but the state itself. They personified the attorney's role envisioned in Rule 6.1b3 of the Rules of Professional Conduct in legislative lobbying to improve the law, the legal system, or the profession. Our country would be better for it had Congress heeded their wise counsel. I'm proud at this point to hand this off to Dot Dobbins to talk about her pioneering work in the area of domestic violence. Dot?
Thank you, Gordon. Both he and Walter reminded me of how very young we all were. And I'm sort of like U.B. Blake. If I'd known I was going to live this long, I should have taken better care of myself. Anyway, I I had the opportunity to work at legal aid, legal services back then, when I was a law student. But this story is really about the revolution in law and society that involved the women's movement in the 1960s and 70s. And I was a part of that while I was a college student and a law student, and while I was living in Nashville. I came to legal services as a law student in 1972. Walter and Ashley hired me. They were third-year law students. I was a summer after my first year in law school. And so I was a clerk at Legal Aid, and then continued there for 14 years after being a clerk for 2 years, and then as a lawyer for 12 more years. I handled mostly domestic relations cases as a young lawyer under third-year practice. That was a lot of what we were doing. And then almost exclusively as an attorney as well. These were the years when there were very few women in practice. I was reminded of a comparison of women practicing law and dancing dogs, to say that it's not that this could be done well, it just shouldn't be done at all, was a quote that was shared when I was a young lawyer. When I was in law school at Vanderbilt, there were 22 women out of 450 law students. But the increasing number of women in law school did bring about a greater focus on women's issues, including a new interest in the area of domestic violence. When I was in college in the late 60s, I was involved with the student YWCA, and then was a member of a national committee called Young Women Committed to Action. And by meeting women from all over the country, came to recognize issues that were women's issues at that time. Leaders in the early women's movement came out of the civil rights movement, where they recognized their own oppression as they worked to overcome the oppression of Black people. They saw the parallels between sexism and racism. During my first year at Vanderbilt, there was a meeting at Scarrett College to address women's issues on a Saturday, and the need for a women's center. And out of that meeting, a women's center was started at Scarrett, which involved starting consciousness-raising groups for women, where women would meet together and recognize and address sexism in their own lives. The Rape and Sexual Abuse Center was also started out of that meeting. As we're at that meeting, I also met a young woman named Alberzine Freeman, who was the director of the YWCA in Nashville. And I shared with her my work in student YWCA and also on the national committee that I was involved in, and she got me appointed to the YWCA board. While I was on the board, we got a grant where we created an organization called, I'm sorry, I'm skipping ahead. We started a Women's Resource Center crisis line, and that was staffed by volunteers. While I was in law school and afterwards, I attended women in law conferences, which were held at various places across the country. And at those conferences, I attended workshops on women's legal issues, including the issue of domestic violence. This was an education for me and for many other young law students and lawyers because it wasn't an issue that I personally had any familiarity with, although later I learned, of course, that domestic violence happens across all class and income lines. But the conferences, I met people from other states where they had shelters where victims of domestic violence could go to escape the battering in their own homes. And they also had protective order laws, which allowed them to seek orders of protection where a judge would order a batterer to leave the marital residence and to stay away from the victim. And also, this brought I brought this awareness then back to my work at Legal Aid. At this time in our culture, though, there was not a general awareness of the seriousness and perniciousness of domestic violence in the community in general. Women often would not report their husbands when they had been beaten. Many times they would not even seek medical attention. They were too embarrassed sometimes to admit that this happened in their own homes. And they felt that they had deserved it because frequently the batterer would tell them they deserved it. They caused the violence, they brought it on themselves. Often women who came to our office at Legal Aid seeking a divorce did not even mention the fact that they were victims of violence in the first conversation that I had with them about filing for a divorce. They were either embarrassed or they didn't think it was really relevant. They just thought that was the way things were in a marriage and that it was normal. We as lawyers had a lot to learn. We had to learn about the victim mentality and that the dynamics of domestic violence. We learned that it's an average, a woman leaves a home 7 times before they finally take any legal action against the batterer. We were reminded that women those days had few economic opportunities. And emotionally, it was tough for a woman to make it on their own, as well as financially almost impossible, especially if they were trying to care for children as well as themselves. We learned not to become part of the problem by getting aggravated and saying, if you go back to him again, just don't bother coming to see me, because too many times they would go back because the batterer would promise again this would never happen. And it wouldn't be repeated, only to have it occur over and over again. So I learned not to say that, but to say, if you need to come back, come back. But if you go back without the batterer getting counseling to learn better coping skills and conflict resolution skills, likely you will be back and you will be hurt worse the next time. And that was true. There were few resources for women who were in domestic violence situations at that time. And it wasn't recognized by police or courts as being a problem that was a criminal in nature. There were not, courts and police would just tell people to make up and get back together. In 1977, the YWCA got a grant that enabled us to start a program called Services to Women in Crisis, and this was staffed by a woman named Callie Hutchison. This was a really very, very minimal first step. She responded to phone calls of domestic violence victims, helped them get education and job training so that they could become financially independent in order to leave their batterers. She referred them to other services, although there were very minimal services in those days. Callie and Phil Davidson, a sympathetic police officer, and I became a speaking panel, and we would go and talk to church groups and civic groups, anybody who would listen to us about the problems of domestic violence in our community. In 1978, I got a grant from the Legal Services Corporation to hire 2 law students, Abby Rubenfeld and Mary Walker, to do court watching in General Sessions Court, where women who were victims of violence often would go to seek to get a criminal warrant. And they did court watching and watched how the courts responded to these victims coming to court and seeking help from the courts, and to determine how the courts responded to these victims. Based on the work of Abby and Mary, we drafted a order of protection legislation, which the following year, Alan Ramseur and I lobbied to get the Tennessee legislature to pass this. That law gave domestic relations victims more remedies by authorizing courts to order the batterer to leave the marital residence and to issue an order of protection that prohibited the batterer from coming about the victim. It authorized the police to arrest a batterer who violated the order of protection and came back around the victim in violation of that order. In 1979, the Tennessee Commission on the Status of Women issued a report recommending that education of the public about domestic violence and that shelters for domestic violence victims be funded by the state. That was not done till quite a long time later, but that recommendation was made in 1979. Without waiting for that, the YWCA Services to Women in Crisis program began working to try to organize a shelter. The first domestic violence shelter in Nashville was opened by the YWCA in 1981 in a house behind the West End Methodist Church in their parking lot. It was staffed and run by the YWCA. When the church needed that property, then the shelter moved to another location. In 1985, the Family Law Section of Legal Services, with the help of Community Education Coordinator Adina Robertson, published a booklet called The Legal Rights of Battered Women. It covered details of divorce, police assistance, warrants, child custody, shelters, and counseling, all written in plain language, either avoiding or explaining legal terms. The Young Lawyers Conference of the Tennessee Bar Association and the Nashville YWCA funded the publishing and distribution of that handbook. I was also involved in other legislative work in 1985 that was of significant financial assistance to women and children. I worked with Alan Ramseur to get the Tennessee legislature to implement a wage assignment law.
Legal services clients in particular needed to collect the wages, the court orders for child support that they'd been awarded. They needed the money. The kids needed the money. They needed to collect the money in order to make up the difference in their grants from the AFDC program. And so wage assignment was the only way, the proven way, to collect that money. And so adoption of a wage assignment program where the court could order, if there was an obstinate client, to have their wages assigned directly to the child via the mom in most cases. We found many allies, and one of them was I think he was maybe the personnel director. I don't know. He may have been the owner of a small company who came forward and said, "Look, this is not hard for us to do." First, many employers were arguing this is difficult for us to do. I mean, this is akin to having an automatic wage garnishment, and those are difficult to manage. And this guy said, "Well, I've done wage assignments. They're much easier to do than garnishments." He was a good ally to sort of blunt the argument that employers were making, particularly small employers, that we can't manage this program. The judges helped a whole lot in this regard because courts and clerks both wanted it. Judges don't like their orders not being obeyed.
This law substantially improved the financial well-being of women and children, and in some cases made it possible for women to leave a violent situation. Much still remains to be done in this area, but there has been some significant progress since those days, thanks to the work of many people, including Jean Crow, who followed me at Legal Aid. What Alan and I have described is the early times when we began to be aware of the seriousness of domestic violence and some of the issues surrounding this problem. And now you're going to hear from Jimmy Lynn and Margaret Bim, who were lawyers I hired to come work at Legal Service, I'm proud to say.
So I have to say, Callie Newsom case was the first time I learned the meaning of the word eleemosynary. In fact, I'd never heard it before, and I probably didn't pronounce it right. It meant that Vanderbilt was a charitable organization. I thought, well, that's pretty interesting. That's great. And that's what Gordon made him do. He made him stand up and be a charitable organization, which is great. An important part of the work of legal aid lawyers over the years has been representing clients with consumer issues, home repair ripoffs, unscrupulous door-to-door salespersons, leases disguised as sales, and other financial practices that target low-income people. The managing attorney of the consumer section in legal aid for more than 50 years has been, and still is, David Tarpley. He has mentored countless young attorneys at Legal Services, myself included, and many lawyers in private practice, For years, he taught consumer law at Vanderbilt Law School, in addition to his duties at legal aid. Back in the day, David, as well as others of us, often were asked to testify at the legislature about financial issues that impacted our clients: usurious interest rates, credit life insurance, and other issues. Not surprisingly, this brought blowback and attacks from powerful people with other interests, but we persisted. The most sustained legislative action for a great number of our clients, however, was led by another young lawyer working in David's consumer section, Margaret Bim.
Thank you, Jimmy Lynn. I feel like I'm part of a Legal Services Academy today or something. This is so great to look out. I've been facing this way and see all of you and see so many of my colleagues. And I want to thank Ashley Wiltshire for writing this book, which of course has culminated in us being here today. Like Judge Crenshaw, Ashley hired me along with Dot, and this was my first legal aid job, first job as a lawyer when I came out of UT Law School in 1976. The next year, in late 1977, I went to the home of an elderly client who wanted a will. While there, she pulled out insurance policies and asked me to tell me what they covered. And she told me, I have paid on these policies for years, but I don't understand them. And I looked at them, and I didn't understand them either. The policies were called industrial insurance. I initially thought the coverage was for work-related injuries at a factory, but I couldn't figure out why she had so many of these policies. These policies were sold door to door in low-income neighborhoods, particularly public housing, and the premiums were collected by agents who came periodically to the policyholder's home. When I looked at the insurance statutes, I saw that industrial insurance had different statutory treatment than ordinary insurance. So after that, when advising clients, I would ask them about their insurance. One egregious case involved a client who had purchased 28 insurance policies from 5 different companies with an SSI income only of $214 a month. She was paying $105 a month on the remaining 27 policies, but she came to us because her husband had died and she owed $1,200 for his funeral and didn't have insurance for it. She felt she could not stop paying the premiums because the agents who saw her regularly when collecting the premiums had convinced her that she had too much into these policies to let them go. In truth, they were practically worthless. The insurance companies and their agents were taking advantage of the fears and apprehensions of low-income people. They capitalized on the desire of many people living in poverty to give themselves and their loved ones a funeral that conveyed a message of dignity and respect that they had maybe been denied in life. I truly was outraged at this consumer abuse. How to fix it was another matter. I knew nothing about insurance law. I learned that at the turn of the 20th century, 2 groups of men in Nashville formed 2 companies, the National Life and Accident Insurance Company and the Life and Casualty Insurance Company, to sell this product. These companies quickly became dominant forces in the economy of Nashville with substantial financial holdings. In the 70s, these companies owned and occupied the 2 tallest buildings on either end of town. And so you can see the L&C Tower there, of course, which we know, those who have been around for a long time. But in the background over there is National Life Tower being built in this photo. I realized I had a lot to learn about the industry, the products, its practices, and the powerful people. So we applied for a grant to hire 2 second-year law students from Vanderbilt, Mary Frances Lau and Beverly Fisher. And together, we wrote a study of industrial insurance. This 141-page document entitled Poor People in the Insurance Industry in Tennessee used case studies of 5 clients. We described the history of the product, the marketing system, and the company's justification for such high premiums. Using data from the publication AM Best, we listed the remarkable profits made from industrial insurance. Obviously, the profits of the two Nashville companies were of great interest to us. By this time, 75% of the policies sold by National Life were ordinary policies, and only 16% industrial policies, the rest were group. Despite this difference, profits from the two were about equal, right at 50%. And with life and casualty, 77% of its policies were ordinary and only 10 were industrial, but nearly 96% of its profits were from industrial policies. Enormous wealth for stockholders was created on the backs of low-income people who purchased the insurance. Our study also discussed the lack of federal and state statutes and regulations governing the product and suggested remedies for the problems. We realized that just publishing the study, distributing it to legislatures, and hoping someone would notice or do something was not going to help our clients. We needed publicity. Mary Frances knew Wayne Witt, the managing editor of the Tennessean. He set up a meeting for Mary Frances and me to meet with John Siegenthaler, the publisher of the paper. I remember this meeting so well. He had read our study. He understood the impact the sale of these products had on our clients, and he knew how these products affected the accumulation of wealth in Nashville. So as a result of this meeting, Siegenthaler assigned two young interns, college students, Carolyn Shelders and Linda Solomon, to do their own investigation. So on Sunday, August 20th, 1978, the newspaper began publishing an 8-part series that covered many of the issues in our study, but it used language that people could understand and also personal detail. Their articles had front page placement on the right-hand side of the top fold with headlines and pictures. They described the fear-based sales tactics and quoted several former insurance agents who said industrial insurance was a rip-off, fraud, and a waste of money. They interviewed the insurance commissioner who told them he had no power to deal with the abuses or regulate the industry without specific enabling legislation. An department head was more candid. He said that the insurance lobby was so strong that I might have made recommendations to the legislature, but a bill would have never gotten out of committee. In its editorial page, the Tennessean called on the legislature to act, a theme that I think we have heard throughout this afternoon. And in the days and months that followed, the newspaper continued to cover the story and support reforms. Now, I had developed a good working relationship with the insurance commissioner, John Neff, early on, and I had confidence that he had a desire to do something to address the abuses, but I knew he was in a difficult position. I consulted other people in the department, but there was one key person I called my deep throat that I relied upon to help me when I was confused about insurance or the law. And that person's name who's assisted me is still a secret, and I remain grateful to this day. Now, as I learned more about this problem, I realized that litigation was not going to get relief for my clients, and administrative advocacy would go nowhere. I knew that remedial legislation was the way to go. Had it not been for a law school class taught by Professor Grayford Gray at UT 3 years before, I would have not known what to do. I mean, as part of that class, I had been an intern at the General Assembly where I learned how to draft legislation and how the legislature works. I drafted the small insurance policy law of 1979 with the aid of a lawyer in private practice, my now husband, Harlan Dodson. We had spent some time together in Judge Kurtz's 1978 race for public defender and his successful race for public defender. And this was a good way for us to see each other. So the proposed law did not contain all the remedies our 141-page document study had suggested, but the bill was what was thought to be acceptable to sponsors in the legislature. So I found two sponsors, Representatives Steve Cobb here of Nashville and Bill Nolan of Knoxville, and they told me I needed somebody in the insurance business, so they asked Senator Ben Longley, who was head of the Commerce Committee, and he agreed, which was really a huge factor in this whole process. So then began the very hard work of getting the bill through the legislature, but national publicity helped. In the late summer of 1978, the producer and staff from the CBS program 60 Minutes, they were in Nashville filming a piece about fraudulent recordings where people who wanted to hit the big time in the Music City songwriters, that people would get money and do recordings and nothing would happen with it. So while they were in town, they read this Tennessean series of articles. And so after they returned to New York, they called and asked me to help with an expose on industrial insurance. So the 60 Minutes reporter, Mike Wallace, came to our legal services office. His team wanted access to our clients. I told him what I'd told the Tennessean. They would have no trouble finding policyholders in public housing. And in doing so, they found several people with multiple policies. They wanted to film me interviewing the policyholders, but I declined. I was worried about the fact that I knew that I was going to be out front in the legislature and didn't want government officials thinking I was doing this for some kind of public attention. So finally we agreed that Mary Frances and Beverly would interview one of the policyholders. And when they told her on camera what she could expect under her policy, she began to cry. And that was the final scene as the 60 Minutes clock started ticking. You know how it goes tick, 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 tick. And there she is, learning for the first time what she had purchased. So as the months wore on in the winter and the spring of 1979, the end of the session was looming, and I began to worry that the bill would not get through the committees and the floor for a vote. And then came a real breakthrough. The Speaker of the House, Ned McWhorter, had not been involved until this time, but he was aware of the intense lobbying, the industry lobbying, and the media attention of the Tennessean and the drag created on other legislative business. So exasperated one afternoon late in the afternoon, he literally ordered everyone that had anything to do with this bill to come to his large conference room. And there were insurance executives from Memphis and lobbyists for several companies and House sponsors and corporate lawyers, all men, and me, a woman, 28 years old. And after all the years since, I still remember the speaker's charge saying, I only have a high school education, and back in the day, I know this insurance had a good purpose, but things are different now, and this product needs to have some changes. I want you to sit here and work it out. He left the room, and we worked it out. That afternoon, in fact, and when the negotiated version of the bill finally reached the floor, it passed the House 93-0, and the Senate 27-0. And as with any compromise, each side wished for more or less, but the legislation as passed went a long way towards curbing industrial insurance abuses. The legislation's major objective was that these small policies had many of the provisions and protections applied to other policies. The companies were required to file policy forms with the department that allowed the department to review the benefits rates and compliance and new standards. In addition, the company was required to provide a statement to be signed by the applicant and agent disclosing the number of policies the person was carrying and the rates compared with the applicant's income. The policyholder had 10 days to review a policy from the purchase date and revoke it. And this was important to me especially. The small policy have to have comparable cash values and loan provisions to ordinary insurance. And really one of the biggest sticking points that we had about the legislation was the private right of action. And I think about that Joe, as I look at you, now that I see that you're here, Joe Lackey Jr., and what your dad was going through. To aid enforcement, the legislation gave a private right of action to the policyholder to sue the insurer if the company failed to comply with the law. When Governor Alexander signed the legislation, he called it an important step forward in protecting consumers. And he added, the bill is a good example of how the public and political processes work together. And Commissioner Neff observed that the legislation already was being regarded as a model bill throughout the South. So I want to tell you about this picture. So this is a bill signing ceremony, and to the left is Senator Avon Williams, and this is 1979. He was the first African-American senator elected in Tennessee in 1969. He came to the governor's office that day, and he says, you know, I've been around here for about a decade, and I've never been invited to a bill signing ceremony. I told you we had a long series of recommendations. He actually had a bill that had all of our recommendations. And so he was a part of this process. Behind him is David Brummel, who was an insurance department lawyer. Angela Murphy is there. She was the intern for Representative Bill Nolan of Knoxville, who was a sponsor. In back of Bill Nolan is Assistant Commissioner Roy Bess. In front of Roy Bess and beside the governor is Senator Ben Longley. In back of the governor is Rob Ledyard, who had a long career at Bass Berry, but at that time he was general counsel with National Life. To the governor's right is Commissioner John Neff. Then you see Harold Love. He had the House side of the bill of Senator Williams' bill. There's Steve Cobb, Representative Steve Cobb. And beside him are insurance representatives, and I don't know their names, from Memphis, owners of companies that had industrial insurance. And then there's me, right there. There's me. Thank you.
Not all of us had Margaret's ability or inclination for that aspect of the work. When our clients had problems that needed attention to legislators or administrators, then we needed somebody who knew how to do things like that. In 1977, the 8 legal aid organizations in Tennessee organized an association, the Tennessee Association of Legal Services, TALS. It was to maintain a brief bank. It was to provide CLE. This was before there was any CLE requirement in the general bar, so we were ahead of our time. And TALS was also to hire someone who could relate to the legislators and administrators on behalf of our clients. That's how DOT could call on Alan to help with the order of protection legislation and the wage assignment. Alan was later succeeded by Stuart Clifton, who then was joined with Representative Mike Murphy, who helped in so many ways. Now, as you can imagine, there was a lot of criticism of this aspect of our work. It came in one year from the Lieutenant Governor, from a former Tennessee Bar Association president who would represent a bank in West Tennessee, and from the general counsel of an insurance company in Chattanooga, among others. They thought we should stick to lawsuits and not represent our clients before the other 2 branches of government. Of course, we know that that's not how the system of laws work, that there are really 3 branches of our government, and many law firms, the size of legal aid or even smaller, have a separate section called Government Relations and Public Policy, where lawyers and non-lawyers do the bidding of their clients where it's needed. And it's not only large firms, but also small firms, and individual lawyers do it on behalf of state agencies and industry organizations and individual clients. So likewise, we needed to do the same thing for our clients. And one of the many issues that Alan and then Stuart worked on for our clients was the school breakfast program, getting it established in schools throughout our state.
So the school nutrition program through school lunch was providing lunch to, hundreds of thousands of kids every week. Well, the feds came along with the school breakfast program, which was 100% federally funded. They paid for all the food and some of the administration. There were places all over the state where there was no school breakfast program, but there was no state mandate nor really state support. And so we began campaigns to try to mandate school breakfast.
It was a tough battle, and it took many years. One story that I remember that was a different battle we had with a sponsor of our bill, a state senator who was sponsoring our bill, and he was in his first term. And he basically, after hearing from a couple of business leaders in a committee meeting against it, said, "I think I've been wrong. I'm not going to be for my bill anymore." And so the bill did not pass that year. That summer, coincidentally, he lost very badly in his reelection to Senator Joe Haynes, and one of his issues was passing school breakfast. So we did ultimately pass that, as Alan has pointed out. From that day forward until this day, Tennessee has the highest percentage of participating schools in school breakfast in the country.
One of the reasons we wanted to highlight the school breakfast effort in this program was because of one of the ethical challenges that arose for Alan while he was working on it.
Senator Bill Owen from Knoxville. Owen was a natural ally. He represented an inner city district in Knoxville. But he was also involved in not only in school breakfast, but in legislation to mandate joint custody. We were opposed to joint custody because we thought that there ought to be a judge ought to be crafting individual custody arrangements for individual kids, and it shouldn't have to be overcoming some artificial burden. And had told Senator Owen that, told plenty of folks that, and we're continuing to argue against that in the Judiciary Committee. Owen was also a member of the Education Committee, and when our school breakfast bill came up, he proposed to me first privately, and then from the podium of the Judiciary Committee, that we should drop our opposition to the joint custody program in favor of, if we wanted to get his vote for the school breakfast program. Well, it was an ethical dilemma for me, but it was certainly an ethical challenge, because he was asking us to trade the interest of one client for another. We had clients that didn't want joint custody, and we had clients that wanted school breakfast, and we couldn't trade the interest of one for the other. It would have been a direct violation of the duty of loyalty, and he did it publicly. Thank goodness he did it publicly, because the papers picked up on that immediately, and he reversed his position the next week.
Well, throughout the program, we've seen that a number of times how helpful the press was at many points during this time. For now, however, I want to finish this first segment of the program, which has to do with cases, with a comment about the variety of our cases. Most of what we've highlighted here are class actions or legislative activities. And indeed, in those 25 years, we were counsel in nearly 70 or more than 70 class action cases. And they brought great relief to many people across our state and many reforms in our laws. But there are two things to keep in mind. One is this: at the same time we were handling those larger cases, we were also doing individual cases that affected not a whole class of folks, but one individual or one family. A conservative estimate is that during that time, we handled 95,000 individual cases for clients who were eligible for our services. The second thing to remember is that it was the individual cases that led to the big cases. Remember, Margaret's case began when she went to a client's house to draft a will, and the client pulled out those numerous insurance policies. Likewise, Gordon's suit against Vanderbilt Hospital began when Callie Mae Newsom came in and asked him to defend her in a General Sessions collection case. So there were various reasons and various ways we got involved in these cases. And here's another one of those cases. It resulted from the illegal treatment of many people across the state, and there were several legal aid lawyers involved in this. But it resulted in a massive class action case that had a recovery for the class of about $750 million. Several legal aid lawyers, as I said, were involved, but Russ Overby and Dave Ettinger from our organization did most of the work.
We represented a lot of people seeking Social Security disability benefits. Back at the time the Samuels case was filed, there were not a lot of private attorneys interested in doing that. Well, right around 1980, there was a seismic shift in Social Security policy with respect to this. They started cutting people off disability who had been on sometimes for decades, even though their condition had not improved. They told the state agency that actually did the initial evaluations not to ask treating doctors about functional abilities. Well, that's where these cases are won and lost. As a result, there was just a tidal wave of people being cut off who had been on, and people who had applied and clearly should have been approved but were not. And what we found is if we appealed and appealed and appealed again, we would eventually win. But that could take years, and we filed a lawsuit in federal court saying you have a right to the correct legal procedures from the get-go at the initial stage. You shouldn't have to be all the way up several years later to federal court or to an administrative law judge before you got a fair shake. The Social Security Administration would have doctors that they hired do evaluations. And one of the most notorious set of doctors would fly into a city in Tennessee. They'd be met by a trailer. They'd climb into the trailer. They would conduct very cursory, I'm talking less than 15 minutes, evaluations of people with very complex issues, and then move on to the next person. They just ran a volume business and made lots and lots of money doing that, and they understood who was paying them. And in virtually every case, treating doctors felt that there were greater limitations than these consulting doctors thought. We based our claim on strong statutory and regulatory language that said your primary source is supposed to be treating doctors, and you are supposed to give greater weight to those doctors. You're supposed to ask them to provide functional information, and if more testing is needed, they are to be asked first to do the testing. Well, that was honored totally in its breach. None of those were being complied with. We filed a summary judgment motion in a cardboard box because it was about 1,000 pages of exhibits and arguments. After a year, the judge granted us summary judgment. The first thing he said is, you got to follow the law. The second thing he said is, you haven't been doing this, so you have to give these 70,000 people another chance for an evaluation where you follow the law. About 30,000 Tennesseans took the judge up on that offer, and they got about $750 million in benefits.
We will now have a 15-minute break.